Housekeeping, we'll do practice tip of the day. We will do just a little bit of Blue Book for a minute. We will go over the rule explanation homework that we did for today. We'll talk about our case, that is your memo assignment. And we will do a little bit of practice rule application, not a little bit, we'll actually dive pretty deep into rule application. And we'll talk briefly about how to do the roadmap, or kind of think of it as C and CREAC. For C, and then hopefully we have a guest speaker today. She's scheduled to come, so I haven't gotten confirmation, but hopefully she'll be here. Homework, at the end of class, pass up your homework assignments. You can keep it for now. For next Wednesday, it's like a lot of things, but they're all pretty short, so don't worry too much. But Brian Garner, 3:11, 17, 18. Judy Fisher, those are chapters, not pages. 3:11, 17, 18. Judy Fisher, these are pages 31 to 32, 38, 44 to 45. Blue Book, page 16 to 17. Bring your laptop if you have one. If you don't have a laptop, that's totally okay. So no one should feel like they have to have a laptop. You'll be able to work with the person next to you. So yes. Remember when I said that there was really light homework one day, and I said not to get used to it. So keep in mind. Okay. What's going on?
I just have a question.
Yeah.
So are you talking about turning in the rule explanation homework that we have?
At the end of class today, yeah.
What if we didn't
I emailed it.
Emailed it?
Yeah.
I
So-
emailed it, but I didn't finish it.
So as a general rule, always email and bring it in.
Yes, sir.
I told one student today that they could just bring it in because they were gonna write it by hand. So, not a huge deal, but make sure that,
Do you want me to just write it down?
make sure that if you didn't, how many people did not email it? Okay, so that's fine, because I think that, because it was written by hand, I think that was kind of an implication. So if you did not write it, if you do not have a copy today, write on a piece of paper to me when you pass it in, I emailed it, and then sign your name.
Okay.
Okay? Okay. Practice tip of the day. Is that all housekeeping? I guess so. Practice of the day is talk to your loved ones about your work. So obviously you have to stay within ethical rules. You shouldn't break like attorney-client privilege or something like that. But whether it's a spouse or a partner or your mom or your dad or your child, sometimes law can have long hours, and it can be a strain on like work-life balance things. And I think one of the ways around that is to the extent possible, make your loved ones a part of your work so that it's not just like totally on-off switch. We actually had a speaker mention this kind of in passing. Kate Crosby mentioned this a little bit. So the way that I did this, or one way, was my wife and I would play a game called You Be the Judge. So she's not a lawyer, but I would come home and I'd say, oh, here's the case that we're working on, and let me tell you the facts of this. Let me tell you the facts, and I'll tell you a little bit of the law, and you tell me who you think should win. And she would kind of play You Be the Judge, and we would kind of debate it. And, it was fun, but it was mainly just a way to keep her connected to my work. Okay, let's make sure that we can. Actually, I'm going to go through it. You don't get laptops out, but I'm going to show you how to go on to ICW, the Interactive Citation Workshop. Actually, I'll just ask you. You're supposed to make sure you can go on. Did everyone find it? Kind of. Yes. Not so much. I'm seeing some shaking hands. So let me ask this: did anyone try to find it and fail?
No.
Raise your hand. Okay. So if you didn't try to find it, you need to have it by next class. If you try to find it and don't find it, then see me before next class, but don't come to class on Wednesday unable to log on to ICW. Okay. And to the people who did try to find it, as was assigned, bless you. Good job. Bless them too for doing the assignment. So great. Let's briefly talk about how to do short form citations. So do we remember this case? Where is it? Right. I guess we can do the Michael Jordan one. I thought we might have the Robertson one, but this is fine. So you will read about this for next class, but we're going to dip our toe in the water so that you're prepared and you don't feel like the blue book is like hieroglyphics or something. So we talked about this case, fake case obviously, and how to do the regular citation form. But sometimes you won't do the regular citation. When would you not do the regular citation? You would not do it if you've already done the regular citation. And so then you get to use what's called the short form citation. What does that mean? Well, it means that if this Jordan v. Bird was the very last case that you cited in your memo, and you want to cite it again, you just do it.
Comma not italicized.
It's a period, not a comma.
I mean-
and it is italicized.
I mean in the top part, in the top right after. Is that? I was just trying to remember.
That should not be italicized.
Not be okay. Thank you.
So let's say you write, there was once a case where two basketball players sued each other, period. And then you cite Jordan v. Bird, 945 F. 3rd, 3142, 6th Sir, 1989. And then you write another sentence, something like, the case was decided by the Sixth Circuit, period. And you want to cite that case again, you would just say id. The case was decided by the Sixth Circuit, period, id. It'd be really bad legal writing if you wrote those two sentences. So what about if you cite this long cite, and then you go talk about some other case, and now you want to come back and cite Jordan v. Bird again. So there was a case where two basketballs sued each other, Jordan v. Bird, 945 F. 3rd, et cetera, et cetera. There was another case where basketball players sued each other, period, Johnson v. Pippen, 946 F. 3rd, blah, blah, blah. Back to that original case, the Jordan v. Bird case, it was decided in the Sixth Circuit, period. Now we want to cite back to that. We can't cite id because that would confuse the reader. That would make the reader think we're citing to the Johnson v. Pippen case. So what do we do for a short form? We do this. What's the rule for this? You do the first party, volume number and reporter abbreviation, and then at the page number, period. And then finally, let's say, I'm going to close that again so don't be confused. Let's say that your first sentence cited the full cite and directed the reader's attention to page 42. And then you cite another sentence, or you write another sentence, and you want to continue to cite to Jordan v. Bird, but you want to direct the reader's attention to a different page. Well, you wouldn't just write id, because then the reader is going to think you are once again directing the reader's attention to page 42. So instead, let's say you want to direct the attention to page 43, we would write id at 43. So just to wrap all that up, yeah, 1 second, I'm going to do Phil Elizabeth. Long form citation, we've been talking about this already. And then short form citations. Before I take Phil's question, Elizabeth's question, is anyone confused about when to do 1, when to do 2, and when to do 3? Okay, yeah, Phil.
I just wanted to ask if you could explain the id at 43 again.
Yep. So if you just write id, it refers to the previous case and the page of that previous case that you directed the reader's attention to. If you want to refer back to the previous case but want to direct the reader's attention to a new page, you do id at 43.
how far could id be from the previous case? Like, is
That's a good question. It's not just id, but also even this short form. Some people do a 5-page rule. So if it's more than 5 pages from the original case, I prefer more of a standard than a rule, which, you know, a rule is like very cut and dry. Standard is more like you use your judgment, you put yourself in the shoes of the reader. Like, how confusing would it be for the reader? You know, if you cited it 120 pages back, the reader probably doesn't remember that it was a Sixth Circuit case. So for your memo, I would recommend, and actually this is for your first memo and your second memo, and for your brief in the spring, I would recommend that for each new full section, you repeat the long form.
Okay.
Elizabeth, what was your question?
Well, he kinda got it, but like for the second one, for example, if you just wanted it to be a different page, you would just change 42 to
Yep.
other pages.
Yep, so let's say that you had written a sentence and then cited the long form. You write another sentence about another case, and then you want to come back to Jordan, but cite to a page other than 42, you would just write that. Occasionally, you will do a cite that does not direct the reader to a particular page if you're referring to the whole case. It's a general rule you want to avoid that because you don't want to force the reader to read the whole case to figure out what you're talking about. But on occasion, it's the appropriate thing to do. You really are referring to the entire case. And when that happens and you want to use the short form, you just do that. And by the way, if you're using the long form, you would just do that.
If it was a range of pages, like page 45 to 46, would you do at 45 to 46 or just?
Yep, if you want to direct their attention to pages 45 to 46, it's at 45 to 46. Priya's hand is creeping higher and higher.
I have 2 questions. So when you say use the long form for each section, do you mean like the short answer as being a section? So not like paragraph?
Not paragraphs.
Okay. And then my other question is like, say it was like, I don't know, 100-something page case, and it's like 105 to 107, would you do 105-07?
Great question, because I was thinking, should we talk about that now or should we talk about it at a later date? Let's just talk about it now. The first number you do, obviously, is the entire number. So let's say it was page 145. Do 145. Let's say it's page, it won't be page 10,000. So 145. The second number after the dash, you should use the last 2 digits. So if it's just a 2-digit number, it's the full number. If it's a 3-digit number, you drop the first digit. If it's a 4-digit number, that won't happen with cases, but it can happen with books that are over 1,000 pages. You would drop the first 2 digits. So again, there's no such thing as a case that has, there's no such thing as a reporter volume with more than 1,000 pages, but let's pretend that there is. You would write it like that. And don't feel like you have to memorize this. This is all in the blue book that you will read. This is just to make your reading life a little bit easier. Yeah, Elizabeth.
What if you're citing like page 5 and then page 7 through 8?
Yep. So
Mhm.
like that.
So like up at the top where the 42 is, it'd be the same.
Yep. It'd be let's say you want to do page 41 and 45 to 47. All good questions? Any other good questions? Any bad questions? Okay. We will practice it. That's why you guys make sure you can log on to ICW for next class, because whether we start next class or the class after, we're going to start practicing this stuff. All right. Next. The rule explanation that you did for homework. Let's take a look at the answer. So here was the original case. We choose to turn first to the question we find dispositive. Whether on the undisputed facts the defendant's intrusion into the plaintiff's privacy was serious or substantial. We know that the defendant called the plaintiff only 3 to 5 times per year. The calls were brief in duration. The calls were polite. The calls were therefore not a serious or substantial intrusion into the plaintiff's privacy. So what's going on here? The court, the Massachusetts Supreme Judicial Court, is explaining the rule. It's explaining the rule for an invasion of privacy. And it doesn't really explain the rule in the clearest way possible. The clearest way possible is to go general to specific, as we talked about and as we practiced. What is the general to specific? Well, let's name the rule, an invasion of privacy. What does that require? It requires a serious or substantial intrusion into privacy. That's stating the rule in its most general terms. But what is a serious or substantial intrusion? Well, that looks to 3 factors. And you can kind of get a flavor of what the 3 factors are by the facts that this court uses when applying those 3 factors. So when you explain the rule, you want to explain it to your reader. Here's the rule, here's a general explanation, and now let me be specific and tell you the 3 factors that inform this inquiry. And those 3 factors are frequency, duration, and tone. Frequency, duration, and tone. So let's close this for a second. That's what I'll see.
I think I passed gas.
Do. Okay. So if you were explaining this, you would say a plaintiff alleging an invasion of privacy must prove the defendant's intrusion is, quote, serious or substantial. We've now stated the rule and we've explained it in broad terms. Now let's get a little more specific. In order to satisfy this element of invasion of privacy, courts look at 3 factors: the intrusion's frequency, duration, and tone. But you know what? We've still not gotten real specific, because how frequent is frequent enough? How long is long enough? What tone is polite enough or nasty enough? Well, we're now going to explain to the reader in more specific terms what that means. For example, in Schlesinger v. Merrill Lynch, the Supreme Judicial Court held that the intrusion was not serious or substantial because defendant Merrill Lynch's phone calls to plaintiff Schlesinger happened only 3 to 5 times per year. That goes to frequency. Were brief. That goes to duration. It's still not very specific, but that's all we have to go on. And we're polite. So what's the rule that comes out of this? We may not be able to resolve every case, but we know that if a call is no more frequent than 3 to 5 times per year, and if a call is no longer than these calls, and if a call is as polite as these calls, then it's not an invasion of privacy. So, Bailey, let's imagine that a call happens once every 5 years. Okay? And let's imagine that the call lasts 20 seconds. And let's imagine that the caller is extremely polite. Who's the Emily Post? Is that the polite, the root? Like Emily Post level polite. Do we think that that is an invasion of privacy? No. And just kind of in layman's terms, compare that case to Schlesinger.
Well, the calls are happening even more infrequently, and they could be even shorter, and they're also polite.
Great, exactly. So what Bailey just did is rule application. What I just did before I asked Bailey a question was rule explanation. Any questions about rule explanation? Now let's turn to rule application. Work with the person next to you on this exercise. There you go. Take one, pass along.
One per group or one per person?
It could be one per person. If they're extra, let me know. 5 minutes. A minute ago, then we do rule Foster's calls, or infrequent, brief, and polite, I'm stating it in general, and then we are now going to connect the dots and explain just how frequent, explain just how brief, explain just how polite, and when we do it to the extent we can, we're going to compare it and contrast it to the facts of Schlesinger, because that is part of the name of the game for rule application. So, Foster called only twice a year, that's how infrequent. Even less frequent than the calls in Schlesinger. So see the comparison, the connecting the dots between Foster and Schlesinger. You say to the reader, okay, we know that if 3 to 5 times per year was sufficiently infrequent to not be an invasion of privacy, then we know that twice a year is also infrequent enough. Foster's calls lasted only a few minutes, that's how brief they were, and Foster began each call, let me tell you how polite they were. Foster began each call by saying, please, thank you, calm, pleasant, and professional. So, we're connecting the dots, we're also doing the Missouri Show Me State thing, where we don't just say to the reader, okay, the test is infrequent, brief, and polite, and these calls were infrequent, brief, and polite. Trust me, no. We say these calls were infrequent, brief, and polite, and let me show you just how infrequent, let me show you how brief, and let me show you how polite. Questions? All right, good. You're ready to write your memo. Yeah.
I have
Go
several
ahead,
questions.
Jake. Go ahead, Jake.
Shouldn't there, in the rules, shouldn't there be like a link given on the calls? in
Ideally,
Schlesinger?
I mean, Schlesinger didn't give us the link.
Okay, that's what I was, I don't know if that was something.
Yeah, ideally, when you are doing your research, not for this memo, because you don't have to do your own research, but for your second memo and for every assignment in your life after that, yeah, you want to go try to figure out, you want to find as many cases as you can until you have really gotten as concrete an answer as possible about what counts as brief. Okay. Yeah.
This is a little off topic,
All right.
about our memo assignment.
Yep. We are going to talk about the memo in a second, but go for it.
Oh, okay, I'm sorry. So in the case that we're supposed to use, they cite like 5 million other cases.
Yes.
When we write our memo, do we have to also cite those other cases, or just, the cases within that, or just the
Yes.
Richfield case?
So I think the memo assignment says not to do it. Let me double check before I tell you.
It does to only.
It does. Someone say it does.
Oh, okay, sorry.
So that again is kind of an artificial constraint on this assignment that's designed to keep it as simple, not as simple as possible, but as simple as possible. We just not do it at all, but much simpler than otherwise. Let's see. Yeah, you should analogize only to the facts of Walker. You should not analogize to the facts of any other cases cited or described in the opinion. Okay, so let's talk about the case. We'll do a little bit of rule explanation practice using the memo assignment, and then we'll do a little bit of rule application practice, and also it will give you kind of a starting place for where to begin. So, Emily Weinweber.
Yeah.
Just describe, what's our case about? What happened to our client?
So he and his girlfriend were drinking. They went to a concert and they went to a bar, but the girlfriend stopped drinking at some point. While the date continued. And then they were driving home and it was pouring down rain, like a torrential rainstorm, and they went off the girlfriend went off the road into a ditch with her big trunk. And so while she was trying to she got out to like push the truck, and he got into the driver's seat to help her reverse or whatever out of the ditch, and a cop came up and basically arrested him for driving under the influence.
Great. And the characters' names,
Oh, sorry.
pretty proud of this. No, that wasn't important. and it's still not important. Loudon Downey, Harriet Dawson, Jimmy Miller, and it's going to Leo McGarry. Does anyone know the references? Elizabeth.
Sorry, so Leo McGarry.
Leo McGarry's from what?
West Wing.
He's from The West Wing, one of the greatest television shows ever. I'll stand by that.
Proud of your dad.
And Dawson and Downey, anybody?
Dawson's Creek.
Nope. Way better than Dawson's Creek.
Anything?
Oh my gosh. Devastated, devastated. F's for everybody. They're characters in A Few Good Men, one of my favorite movies.
Oh,
Moment
has
Okay, so great job, Emily, on the facts. Now let's talk a little bit about the law. We learned about the law. Let's start. Where do we start? We're trying to figure out the law. What's the when we're trying to figure out a statutory law? Where do we start? This is like a Jeopardy category, stupid questions.
Statutes.
Yes, exactly, Emily. You're trying to figure out statutory law, you start with the statute itself. So in this case, the statute says, let's see if it's on, should I give it to you? Yes, the statute provides, this is the top of page 2 of your memo assignment. It is unlawful and punishable as provided in this section for any person with a blood alcohol content of 0.08% or greater, as shown by a chemical test given within 2 hours after the alleged operation or physical control, to drive or be in actual physical control of a vehicle within this state. So there's the full statutory text, and there are 3 key words in here that are going to be relevant to our inquiry. Our case is going to hinge on the meaning of these 3 words. Sydney, what are the 3 words? You know this. You know this.
The actual.
Yep. Yes.
Physical control.
There you go.
Whatever.
Actual physical control. So the statute will not apply to our client unless our client was in actual physical control. Why is that? Our client was not driving the truck. The rest of the statute, unfortunately for us, definitely applies to our client. Like, he was drunk, but the rest of it, the rest of it applies. Drive does not apply, but it doesn't say drive and actual physical control. It says drive or actual physical control. So all the prosecution has to do is satisfy one or the other. It goes back to the and versus or thing that we talked about way back when we did the cemetery rule. So now it's driving, but maybe our client was in actual physical control. So what does actual physical control mean? Richfield City v. Walker gives us some taste of what that means. So there's a rule, McKella, that Richfield tells us about what actual physical control means. So it lists a bunch of factors to consider that are not going to be unique to this Walker case, and they're not going to be unique to our Downey case. They're going to apply to every actual physical control case. What are the factors that will inform whether or not a defendant was in actual physical control? Did you do the Walker case? No. Okay, so would you like to phone a friend?
Sure.
Volunteers? We do so many volunteers. Zach?
I did the wrong reading.
Wrong reading, Zach.
From the syllabus.
Alex. Leah's going to save Alex.
You talking about the 9?
Huh?
The 9?
Yes.
Okay, so whether they were asleep or awake.
So if you have the case, it's on page 93 of the case. It's the last page.
The position of the automobile, whether the automobile's motor was running,
Okay, so
whether they were positioned in the driver's seat, whether they were the sole occupant of the vehicle, whether defendant had possession of the ignition key, whether they had apparent ability to start and move the vehicle, how the car got there, and whether they drove it there.
Exactly. So very helpfully for us, not every case will do this. This case has just explained the rule in one paragraph. Now, each of these factors, you might want to explain in more depth, and it gives us a flavor of what that is in terms of how it applies here, because it's kind of like Schlesinger. Schlesinger says, we're going to look at frequency, duration, and tone. Those are 3 factors. Walker has 9 factors. Frequency, duration, and tone. But Schlesinger gives us a little bit of more explanation about what frequency means, because it says that 3 to 5 times per year is infrequent, counts as infrequent. So what is infrequent? We know 3 to 5 times per year is infrequent, and then obviously anything less than that would be infrequent. Is 6? We don't know. 7? We don't know. 3 to 5? We do. So, that's some important rule explanation. Now, Alex, back to you. Let's do some rule application.
Okay.
This prosecution against Walker, Walker guilty or not guilty? Actual physical control or not actual physical control?
Guilty?
Guilty, yep. So, why? What are some of the things that Walker?
In the driver's seat.
Yep.
The ignition was in the car.
Let's list them. In the driver's seat. Ignition.
Ignition.
Keys in ignition. What else?
He wasn't by himself, but that's still.
Yep, so
it's
we can
not
list that
still-
over here.
Yeah.
And I think they're actually not sure if he's sitting in the driver's seat or if he's kind of slumped in the front or something like that, but they say like, close enough.
Is there one with control? Is that what?
Well, it's all going to control, but let's see. Are you thinking of ready to go?
Yes.
It seems to be something they're really focused on. You look on the last page, second column, near the top. It says, if he is ready to go and the potential for tragedy is present. It is this circumstance that the legislature specifically wanted to prevent when it enacted laws prohibiting a driver from being in actual control of a vehicle while intoxicated. So, to some degree, all of these factors get to, are you ready to go? Are you close to ready to go? What else? Anybody else note other factors to consider? Priya. What else matters to this court?
Are we looking at like precedent case?
At the Richfield City v. Walker, trying to figure out, okay, we learned from this case that Walker was an actual physical control.
Yep.
Why? And the court says, after lots of other stuff, on the last page it says, okay, we're now going to take one paragraph, it's a long paragraph, but one paragraph, and we are going to tell you why Walker was in actual physical control. So it says, in the present case, the following facts are relevant.
The motor wasn't running.
Okay, so that's over here. Motor off.
I thought he was by himself.
Let's see.
Technically, he's by himself in the cab if the girlfriend's pushing it.
Oh.
No, we're not
No.
talking about our case, we're talking about this one.
Yeah, it says he's by himself.
So Walker is by himself.
Yeah. Also, even if we were talking about our memo case,
Mhm.
wouldn't he be by himself because he's the only one in the car?
Yes.
That's what they're
I would think that would count as by himself.
Okay.
But let's do this one first, we're gonna get to that in a second. Okay, so defendant asleep, keys in the ignition, also headlights are on. Look, headlights, they speak to ready to go. Keys in the ignition, speak to ready to go. Driver's seat speaks to ready to go. It says that the car could easily be moved, capable of driving off as soon as he woke up. So he was asleep. That's got to go on the list of maybe not in control. But he was in a position so that as soon as he woke up, he'd be ready to go. So I think we just put that in the ready to go. Okay. It says that the car could easily be moved. So I guess presumably like if the car was out of gas, maybe it would not be easily moved. When I read this, I wondered like, well, when would a car not be easily moved?
There's something in front of it.
I guess like if you're like blocked in,
Yeah.
you know, if you're like parking at Derby or something in someone's yard and there's like 3 cars behind you. Slash tires? No.
Hmm.
now let's talk about our case. So Leah, you got us started on it. It's great. Let's compare our case, the Downey case, to this. So these are the things that might lead to, that do lead to, okay, you are in physical control. These are the things that might suggest you're not in physical control, but they weren't enough in Richfield v. Walker to show not in physical control. So tell us a little bit, compare and contrast our case to this case.
Me?
Yeah. Or just start with one fact that in our case is either similar or different with this case.
Well, he definitely had the ignition, like he had the keys in the ignition.
We use a different
He was
color.
trying to literally start the car.
So put W for the Walker case. I do wish that this Walker case was not my last name.
Yeah.
But it is what it is. Okay. So this was like that. Good. What else? Yeah.
Was it easily movable? Because it's stuck right now, right?
Yeah, I mean, I actually think that to some degree.
But they were trying to get it unstuck.
Yeah, but if it's stuck, it's not easy to move, right? Like if I'm stuck, I can't move.
Yeah, I think that. I think that. I think we could at least agree that the car in Downey's case was not as easily moved
Okay.
as the car in the Walker case. But also, I think, hopefully we could agree, it was more ready to be easily moved than if you're blocked in by 4 cars in someone's yard at Derby. Yeah, Jacob.
The truck was stalling out.
The truck was stalling out.
Still wouldn't start.
So,
I don't know if that makes it go with easily moved.
Can I go with motor?
what'd you say? Motor off?
I guess yeah, motor off, but in a more extreme way.
Yeah, so we could maybe say this.
Was extra off.
Yeah, because it was stalling out, but they thought that they might get it to not stall out. Right? It wasn't like doomed
Yeah.
until, wasn't definitely doomed until AAA arrived. I'll give you a heads up that I think that our guy, Downey, is guilty. I think our guy, Downey, was in actual physical control, or at least the prosecution has enough evidence to go to a jury and make the case that he was in actual physical control. Yes, Shelby.
Okay, but like, what about in the case, like if, I know when I was younger, like our car would get stuck and my dad would literally put me, a child, in the front seat in the car neutral so he could push it. But I wasn't in physical control of it, just like a drunk person couldn't drive. So what control do they actually have?
So I think you're raising multiple questions, at least 2 questions. One is, there's a difference between a drunk person not being able to drive well and a drunk person like being able to drive. So like, you might have literally not been able to drive because your foot might not be able to press the pedal when you were 5 years old or something. But a drunk person can drive, it's just illegal and ill-advised, and they can't drive well. Then were you as a 5-year-old in actual physical control? I think that the test would be, let's apply the 9 factors and we would go through it. Maybe that's the memo I'll sign next year. So I mean, actually, let's just, so if you have the case, take a look.
This is the reference case?
Yeah, this is Richfield City v. Walker.
Okay.
There's 9 factors that are part of the rule.
I think it's these right here.
According to this, at least, they would ask, was 5-year-old Shelby awake or asleep? Awake, so that suggests some control. Position of the automobile, let's say that suggests control. Was the motor running? Let's say that suggests control. Defendant was, although we said it was in neutral, but still the motor was possibly on. Defendant was positioned in the driver's seat, control. Defendant was a sole occupant, control, because your dad's pushing. Defendant had possession of the ignition key, I think control, like you're in the driver's seat and the key is right there. Defendant's apparent ability to start and move the vehicle, so there maybe not control, because if your feet can't touch the pedal, you can't move the vehicle. How the car got to where it was, well, you didn't drive it there, so that bodes well for you, not control. Whether the defendant drove it there, you didn't do that. So, was Shelby, let's just show hands, who thinks Shelby was in control?
By the rules.
You said they're a drunk child? I I mean, obviously you would not be guilty of violating this statute because this statute requires intoxication. So I do think Shelby was not in control. And then there's some abstentions. But the majority of the voters think not in control, which is good news for Shelby. I think this actually goes to why 9-factor tests are pretty dumb as a general rule, because they don't really tell us a lot about how future cases should come out. If you have 9 factors, it's a pretty decent chance that the next case that comes along is going to be kind of 5-4, 6-3, 7-2, but what if the 2 are really important factors and the 7 are less important factors? So if you ever have a chance to take a seminar that really explores the difference between rules and standards and why standards that have 9 factors are recipes for judicial activism, I encourage you to take that course. But we're stuck with this test. Yeah, with the
What is the second part of the rule, the position of the automobile mean?
the position of the automobile. I mean, maybe is it ready to be moved? So maybe it goes to car easily moved. And if you kind of follow along in that next paragraph, to the extent they're kind of going in order.
So when 7 says defendant's apparent ability to start moving the vehicle, that's not about the vehicle itself, that's about the defendant.
Defendant's apparent ability to start the vehicle.
So
Where
is
is
that 7? So I'm comparing
Okay.
2 to 7. So is 2 more about the actual vehicle's ability, like it being stuck in a ditch versus on a road, and 7 more about the defendant themselves, like a drunk person who can reach the pedals versus the child who can't?
Yes.
Okay.
I think that's how I would read it. The number 2 is focused on the car, and number 7 is focused on the defendant. But are there going to be some overlap with these factors? Almost certainly. There's 9 factors. How could they not overlap? Sure, kind of a dumb test. But, it's good practice. Lots of your cases in the future will have dumb tests. Okay, so what have we've done keys in the ignition, we've done car easily moved, we've done the state of the motor. Was Walker in the driver's seat?
Yes.
Yep. Was Walker by himself in the car?
Yes.
Yes. Headlights weren't on, but I keep saying Walker, it's Downey, but right? Yeah.
Yes. Oh shoot.
Were the headlights on? They weren't, but I think that the Walker case suggests that kind of the headlights and the ignition are part of the same inquiry there. Asleep? Was Downey asleep? No. So if anything, the case is even stronger against Downey, at least with this factor. Okay, let's see if there's other things here. Asleep, ignition, headlights. Driver's seat, headlights. Oh, it was headlights. Yes. Not only headlights, but windshield wipers. The door was open, so like maybe we think, wasn't really like super ready. So we can put that on this list over here. But how hard is it to close a door? Not that hard. Yeah.
For the position of the automobile, would that be like the fact that it was in a ditch versus like on the road or in a parking lot?
Yeah, I think like stuck. Like it was stuck in a ditch. But again, they were trying to get it out of the ditch. So how imminent was the unstuckness? Like maybe fairly imminent. And maybe we want to even like investigate like how strong was Dawson? It seems like Dawson was like pretty strong woman, like pretty able to push the truck. So ready to go is kind of the ultimate inquiry, but we have lots of factors that suggest ready to go. Driver's seat, headlights, key in the ignition, and awake, not nothing. We have a few factors that suggest not ready to go. The door was open, gear shift was in park. Not sure that's going to be enough. So when you do your rule application, you want to list all the factors that show actual physical control. And you want to compare those factors to the factors in Richfield v. Walker. And then you should also be upfront about the factors that cut the other way. Factors like the motor was off. But then you say as part of your rule application, although this cuts the other way, it wasn't enough in Richfield v. Walker to disprove actual physical control. So although this is a factor, it's not a dispositive factor. Just as it was not dispositive in Walker, it's not dispositive in Downey. Shelby Boyd.
Yes.
Let's go through the nine. Do you have your case?
No.
Can you borrow it from someone who have a hard copy case? Okay, so I'm on the last page. It says, in summary, we looked at the totality of the circumstances. It lists 9 relevant factors. Let's walk through the 9 relevant factors for our case. So we're going to be down. So in our case, the Downey case, truck stuck in the ditch. Okay, factor number 1, was the defendant asleep or awake when the cop discovered him? Awake. So that's going to cut in favor of actual physical control. We'll check mark for that. The position of the automobile was kind of stuck in a ditch. So I'm going to put this as check and X. X because it was stuck in a ditch, so it wasn't like completely ready to move. But they thought they were pretty close to getting, they thought they had a chance of getting it able to move. That's why they were pushing it in the first place. So kind of in the middle there. Number 3 was the automobile's motor was running or not running?
I think so, because they were trying to get it out of the ditch, right?
Yeah, I'd have to double check. It was in park, but I think that the motor was running. But the defendant was positioned in the driver's seat?
Yes.
Yep.
How are you gonna push
Was the
it
defendant the
so
sole
hard?
occupant of the vehicle?
Yes.
Not looking good, Zach says. Whether the defendant had, he's Tom Cruise as attorney. Whether the defendant had possession of the ignition key?
Yes.
Makes sense, yeah.
Defendant's apparent ability to start and move the vehicle. What do you think?
I would say yes. If he was capable of getting into the driver's seat, I would think he would have the ability to turn the key.
Yeah, I
in
mean,
ignition, but I think that could potentially be argued.
if we're looking at the state of the defendant, not the state of the car, because, was it Shelby who pointed out that, no, Elizabeth, that there was really number 2 that's looking at the state of the car, number 7 is looking at the state of the defendant. The defendant seems pretty able to start and move the vehicle. How the car got to where it was found. So this is kind of, did the defendant drive it there?
No.
No. So that's good for the defendant. And whether the defendant drove it there. Well, actually, once again, 8 and 9 just seem to like very, very overlap. So, welcome to the dumbness of the test.
Could you, this is really small, but could you make an argument on 7 that it says the defendant could start the vehicle instead of a vehicle? Because I think it said in there that he was trying, like he tried the ignition, but like it wouldn't work or something. So he wasn't actually able to start the vehicle, although he could another one.
So I think that's great analysis. And I'm not sure that that's the best reading of it, but it's a reading that a court might take, so you would want to factor that into your memo. And it's also a reading that's good for our client. So even though this memo is supposed to be predictive and try to persuade the reader that you're right about how the case will come out, you know your audience, and your audience will at least want to know, like, what are some counter arguments or some factors. So, if we read number 7 to be focused on the automobile and not the defendant, then number 2 and number 7 seem similar enough that one of them is superfluous. But we just found out 8 and 9 seem pretty redundant. So who's to say 2 and 7 aren't? So we list these 9 factors. To the extent that we can compare each of these check marks to a fact in Walker, that should be part of our application. Because look what we have. We have 1, 2, 3, 4, 5, 6 clear check marks, 2 clear X's, 1 kind of in the middle. Well, okay, there are more check marks than X's, but does that mean actual physical control? Walker doesn't tell us that. Walker doesn't say it's like a counting thing. Walker says it's a totality of the circumstances. Some factors probably ought to be considered more important than other factors. So how do we know what 5 check marks and 3 X's mean? Well, we look to Walker. And if Walker had a check where there's always a check, and an X where there's always an X, and if Walker was actual physical control, then Downey should be actual physical control. And even more so, if Walker had a check where Downey has checks, if Walker had an X where Downey has X, and occasionally an X where Downey has a check, and yet Walker was still actual physical control, then Downey is all the more so actual physical control, just like the Schlesinger thing. If 3 to 5 calls a year was infrequent, then we know that 2 calls would count as infrequent. So you explain the rule, you use the 9 factors in explaining the rule. To the extent that Walker tells us specific things about some of those factors, you make that part of your rule explanation. And you do all this in the memo before you mention Downey's facts in your discussion. And then after you've explained the rule, you turn to rule application, and you compare and contrast Downey's facts to Walker's facts. And you apply this 9-factor test to Downey's facts. By the way, you should not spend a full paragraph on each factor. I mean, some of these can be dispensed with in a sentence. It may even be that some of these can be dispensed with in half a sentence each. You might deal with 8 and 9 in just one sentence. So without worrying too much about like how it will look on a page in a memo, do you have a general idea of just how this test worked in Walker and how this test will work in our case? Good. All right, questions? Awesome. All right. Our heads straight. That's great. We talked about CREAC.
Crack.
Go ahead. So in your discussion section of your memo, the heart of the memo, conclusion, rule explanation, rule application, and then conclusion again. I'd suggest that for your memo, say discussion section as a heading, and then have one paragraph that satisfies this C. And that one paragraph should be, whether you want to call it a roadmap, an umbrella section, whatever it is, just tells the reader, okay, here's the rule, and here's the application in one paragraph. What would the simplest version of this be? Downey was guilty of drunk driving because he was drunk while in, quote, actual physical control of the vehicle. He was in actual physical control because, and just in like 1 or 2 sentences, explain why. Yep.
So because should be the roadmap.
Yes, so, yes. You say it is the roadmap. It's the transition to the roadmap.
It's a sign to the road. No, I'm kidding.
Yeah. Okay. All right, let's do a Garner game.
Kind of hyped this morning, but I don't know why.
I'm gonna need a lot of coffee.
Huh?
So I'm gonna need a lot of coffee
For this weekend?
for this drive.
Oh, yeah. Who you driving with?
My girlfriend.
Oh, yeah. Okay, good.
My parents already left.
Dang.
My brother doesn't leave until later, but he's coming from like around Indy.
Oh, he's right there. He said
The drive.
All right.
5.5.
We did Garner section 10, basic number 1.
I
last
drove to
class.
Columbus, Ohio last weekend, so
We did section 1, you said?
It was the one with only in it.
Yup.
So now let's do Garner, section 10, basic number 2.
Oh, no, this was double negatives, or
Multiple negatives, yeah.
multiple negatives rather, in section 10.
Yeah.
What we did for.
But it had the solution to section 10, basic number 1, had the word
Oh,
only.
that's right, okay.
So do basic number 2.
Are we in groups or?
Yep.
Okay.
We do basic number 2.
Yeah.
In the absence of.
Are we writing on the board today?
No.
No, I don't think so.
The court should resume.
In the absence of any proof to the contrary, so contrary. Not absence and contrary. So
There's no proof.
Administrators functions, I think, have not ceased. Sam, where's the negative there?
Actually, the have not ceased.
Have not ceased. And what's a way to say not ceased that's positive instead of negative?
Continuing, in effect.
Yep. So let's see, group number 3 said, the court should presume that the administrator's functions have continued, good, unless there is proof to the contrary. So that seems great to me. The court should presume that the administrator's functions continue unless there is contradicting proof. That also seems great to me. So we'll let, and then 5 has the same thing as 3. So we'll let the evens, this is close, but I think, there's some like minor stylistic differences. They both like knocked it out of the park, all 3 groups knocked it out of the park in terms of getting rid of the multiple negatives. But then kind of at the margins, let's not just call this a tie, let's have a winner. I'm gonna let the evens vote. So the evens, who likes this way of phrasing it the best? 1, 2, group number 3. Who's voting for group number 3? 5, 6. All right, and who's voting for group number 1? 2, 3, 4. Zach doesn't get a vote. So group number 3 gets the Garner points. 50 points to group number 3.
Well, they already finished, and if it's about speed, then there's no point in writing them.
It's your call. Okay, where's my? You're just doing what you were doing last Congratulations. Is it still through the county clerk's office?
Oh, yeah.
Okay.
They do a lot.
Okay. That's federal, I mean, that's state, right?
Yeah, but it, the local and state have concurrent jurisdiction, so, yeah, so, but I work for both.
So ABC and legislative.
thanks for the paper, man.
Okay.
Did you want this before you left?
Yeah, I'll do it. I was thinking we should do that. No, let's do it with that. Okay. Very excited about our guest speaker today. She's been a public servant for he brings with us, a wealth of experience. She was a graduate of Central High School and Kentucky State University. She earned her law degree from Brandeis in 2006. Since then, she has been both a public defender and a prosecutor, and in between for 5 years, she did a very courageous thing. She opened her own law office and hung a shingle. She comes to us today from the Jefferson County Attorney's Office. In the past there, she has prosecuted neglect and abuse of children. She's now working with the city on legislative drafting and also with the state on alcohol and beverage control. So please welcome DeAndrea Baltimore.
Thank you so much, Professor. And thank you so much for this opportunity to talk to you all. I tend to be long-winded, so what time does the class end?
It ends around 10.
Oh, really? Oh, so I have about approximately, so I'll talk for like 10 minutes, and then you all can ask me any questions you would like. I'm starting my time because I tend to be long-winded. But thank you so much for this opportunity. I've done this maybe 4 years.
Every year.
And I've come to the professor's basic legal skills class. Is that what it's still called?
Lawyer skills, but same difference.
Lawyer skills, okay. So I know that a lot of times lawyers will come in here and they'll talk legalese and things, but that's just not me. a little bit about myself. I grew up in the West End of Louisville, Kentucky. I have a twin sister who's a principal of a school in Philadelphia. She started off in law, and then she was like, look, I can't do this. So she would rather deal with like crazy kids up in Philly. So, yeah, and she, okay, so I know I have my time. I have so much to say. So there's 3 points that I want to say. Number one, buckle down and focus now. I hated law school, absolutely hated it. Maybe you all enjoy it. I talk to like other lawyers and friends that are running for judge right now that I'm not going to say. And they were like, we hated law school. And I was like, I thought you enjoyed it because you would be talking in class. And they were like, no, we hated it. But we were focused because we knew we had a goal of being a lawyer. So please just focus and buckle down. All this is important. I was looking at like service, and I've had cases that the judge had to dismiss because we didn't have proper service. So, service of processing things, I think that's what you all were talking about. I didn't know specifically, but I saw the certified mail piece and all that stuff. But everybody has the due process, notice, and an opportunity to be heard. But anyway, so I went to Central High School. I was in a law and government mag. Now, I remember you, because you were in the program at Kentucky State, right?
Yes, ma'am.
Yes. And I attended, and her dad is a retired detective, police officer with Louisville Metro, Detective Fields. Yeah, he was my buddy. That was my buddy right there. He was crazy. Okay, so a good crazy. So I attended Central High School, where I was in the law and government magnet, because I knew since third grade I wanted to be a lawyer. And I didn't have any lawyers in my family, nobody to look up to, but I always wanted to be a lawyer. So my twin sister and I said, we're going to be lawyers. So we were involved in Central High School's program, and I interned at Densmore and Show. Well, now it's called Densmore. It was a corporate firm. And I did that for a year, and I was thinking, dang, I don't want to do this. So I was exposed to the corporate world. I knew that, it's a ton of money there, but it's boring. And I see a lot of my coworkers started off at corporate firms, and now they're working in public service, as a prosecutor or at the county attorney's office. And so I made a lot of great contacts at Densmore, and I've been away from Densmore 20 years, and I still have dinner with a couple of the partners, and one of them licked the plate during one of our dinners. But anyway, with his tongue. But a couple weeks ago. But, I'm sorry, I'm telling too much information. But it's the relationships that you make with people. Because I always thought, oh, he's this big partner at this big firm. And then you see them eating dinner and they're licking the plate with their tongue. Okay. So I was admitted to U of L's law school. Basically, Professor Powell said, you're going to see the 3 years of law school as one big blur. And it is. It goes by pretty quickly. And even though some days appear longer than others, but just stay focused and buckle down. And don't forget that your reputation starts now. Everybody has a rep. Everybody does. It's like there's a long-winded person that wants to talk all the time. I was a quiet one that just wants to get through. And there's people that come in smell like marijuana, or there's people that that just aren't focused or just don't come to class. And your reputation as a lawyer is everything, and it starts now. And I remember Professor saying, Professor Eads, back when he was here, he was a torts professor. He said the people that you're going to be working with are sitting next to you. And I was like, whatever. And my friend Annie O'Connell, we were arguing. She's running for circuit court judge, and we had a case against each other, and we were objecting so hard. And I thought to myself, I said, Professor Eads said one day we would be opposed, on opposite sides, making arguments against each other, and it was true. And your colleagues, it starts now. Your reputation starts now. She's actually running for a circuit court judge. And basically, your reputation starts now. Buckle down and focus, and absorb everything while you're here in law school. It's 3 years. If you need to take a vacation and get away, take a vacation and get away during the summer or spring break, and just, take your time. You need that time, because I think I worked a little too hard and a little too much, and I didn't have any outlets, so I think that's important. And also, the third point is choose a career that you enjoy. Now, I interned I know that you all have internships and externships here. I interned at the Human Relations Commission. They did discrimination law. I wasn't really interested in that, but I was exposed to it.